Another issue that becomes to the forefront, possibly a little more, with the due diligence period and the right to terminate the contract, and that being done into a certain due diligence period, is the backup contracts. Every contract that is now in multiple listing, I would say every, I guess there are exceptions to every rule, but the overwhelming majority of the contracts in multiple listing will be due diligence contracts, and they'll have a time for expiration. And that expiration, if it's terminated, that house will be back on the market. Well, if I really wanted that house, then I would have a backup contract in place. So if that one first contract were, for whatever reason, to not go through, then I would be there. There wouldn't have to be any further negotiations. The house, that contract would basically spring into effectiveness. The seller, as under the due diligence that we have in South Carolina, that due diligence period, the seller does not have to stop marketing the house during that time period. So the seller could actively market the house and accept backup contracts, fully enforceable contracts, should the contract prior to it fall out. Now it would contingent upon all pending and contracts that are being unenforceable, and there being no lawsuits brought for that. And then the other contract would become the primary contract. There is your Form 391 that you can attach, and it's a general addendum clause. I have said often that whether you like all the forms put out by SCR or not, you can pretty much assure that SCR has a form for that. There are a bunch of them. They do a good job of having forms, trying to do all they can to keep the market flowing without agents having to write language, since we know that's the unauthorized practice of law. So it would be possibly and behoove buyers to look at putting in backup contracts. Certainly will behoove sellers to accept backup contracts, because with those, they have far more bargaining power of whether will or will not make any repairs requested by the buyer. And so that gives the seller some bargaining power. It certainly gives, if I were the first backup contract, it gives me a sweet position should the first one fall out. I do think, however, with backup contracts, though, there should be a provision written. Of course, attorneys are going to have to write these provisions, but there would be a provision written for the unilateral release or termination by the buyer. Therefore, if I put in a backup contract, maybe I'm the second one in line, or even the third one in line, and I find something else, then before my backup contract became the primary, I believe is the word used, the primary contract, then I should have the right to terminate that. So I could then purchase something else I found, rather than having to wait for a closing on the other contracts. That's a whole nother issue that's coming up, but I do believe it'll be a primary issue in the market with this due diligence until we find out exactly how it's going to be handled. Certainly, if I lost the house that I thought was my dream house, then I would want to put in a backup contract to possibly be able to be first in line should the other fall apart.